Hello, everyone. My name is Robert Haniver. I'm a Senior Associate in LK Shields. Welcome to today's webinar, and thank you for joining us. Before we begin, I'll just speak to a few housekeeping matters. I see that a message has come up on the system there anyway. We should have time for some Q&A at the end of the webinar. So if you have any questions for any of our panelists, you can pose them via the Q&A button on your Zoom toolbar. We're going to launch a snap poll here now in a moment. So this will be live for a few minutes, and we'll review the results at the end of the seminar. So in terms of background for today, Ireland's key legislation dealing with anti-bribery and corruption came into operation nearly 3 years ago, consolidating the previous legislation in this area and including new offences relating to corruption occurring both within and outside the state. The strict penalties for offences and the extension of liability of corporate entities for the corrupt actions of their employees and agents means that organisations should have in place robust compliance programmes and measures that instill a culture of compliance from the top down, which in turn can be a defence against the damage that can be incurred by falling foul of the anti-corruption legislation. During today's panel discussion, we will hear about the Irish legal framework relating to bribery and corruption, including its position as part of wider reforms to tackle economic crime and corruption, and the offences, penalties, and possible defences. We'll also hear about the role of the Garda anti-corruption unit, its approach to enforcement and defences, and also the steps that organisations should be taking to best position themselves to avail of these defences. So today we're kindly joined by Detective Sergeant Dan McGinty, who is the Detective Sergeant in charge of the Anti-Corruption Unit at the Garda National Economic Crime Bureau. Daniel is responsible for managing the prevention, disruption and investigation of serious and complex bribery and corruption, farm bribery and sports corruption. We're also joined by Elaine Hughes, who is a director here in LK Shields of our corporate governance and company secretarial practice. Elaine has extensive experience providing advice and assistance on all aspects of company secretarial, corporate governance and compliance matters affecting companies, directors, shareholders and other stakeholders across a range of company types, regulated, unregulated, listed, public and private. Kevin Hart, who is Head of Business Intelligence, Investigations and Cyber Risk at Kroll. Kroll is the world's premier provider of services and digital products related to governance, risk and transparency. Kevin has over 20 years of experience investigating fraud, corruption and money laundering and advising on forensic accounting and providing litigation support. And finally, we're joined by Peter Bolger, who is the head of LK Shields IP and tech practice and advises companies on advisory and transactional matters. With the expansion of traditional corporate governance in broader areas of regulatory and best practice, Peter works with a cross-disciplinary team within LKS to assist clients in understanding legal issues, preparing risk assessments and policies and procedures to assist in minimizing these risks. Peter is highly ranked in Ireland and globally in the complementary areas of IP, tech and privacy. So I see the poll is still up there. We'll give it another moment or so, but in the meantime, we may as well launch into things. Yeah. So I suppose I'll kick off things with yourself, Peter. I think the logical point at which to start today's discussion is if you could identify the key Irish laws relating to bribery and corruption in Ireland.
Yeah, that's great, Rob. Thank you very much for that. I think to frame today's discussion, what I'll do at the outset is maybe stick to a brief outline of the actual Criminal Justice Corruption Offences Act 2018 and maybe bring us through I suppose, the key provisions of that that frame what we want to, I suppose, put in context today. So as you briefly outlined in the introduction, the 2018 Act does replace to a large extent a lot of quite old laws, even dating back to 1889, but that had been updated over the course of the intervening years and consolidated them. And it did that, came into force itself in July 2018, but what it did was it updated the laws in line with international treaties, but also in line with some of the recommendations from the Mahon Tribunal report. And before, and without taking away from the overall context of really what is the broader context of the laws in this area, if we focus initially at least on sort of the pure corruption offences that we're talking about today, and within that, I suppose the key definition really is corruptly. And in the context of the 2018 Act, corruptly is a non-exhaustive defined term, so it's very broad, and it's one of these definitions that we as lawyers would sort of say it includes and doesn't end, and it essentially includes anything that has an improper purpose, either personally or by influencing another person. And then it gives some examples which are non-exhaustive. So that could be, for example, being false or, a misleading statement. It could be withholding or concealing something, be it in the nature of a document or information, or even thinking back to the Enron days, destroying information or documents, or it could be anything by any other means. So when doing something corruptly, it is essentially very, very broad in the context of what we're talking about. In terms of the essential things that are defined as offences, what we're talking about is active and passive corruption and active and passive trading and influence. And two key things in considering, either in terms of policies or preventing corruption in an organization or in a corporate, is you need to think of it in terms of A, where the Act mentions a person, or B, where it mentions an official. And this is obviously key in terms of it. I'm not really focusing this afternoon in terms of the officials. So clearly, if you're dealing with Irish, international, European officials, you need to be even more cautious. But when it comes to corruption, you're talking about corruption in the context of any person, or when it's trading and influence, it's in connection with an official. What's key here again is the broadness of the offence. So it's directly or directly offering perhaps a gift, a consideration, or an advantage, as the Act defines it, or receiving that gift, consideration, or advantage is what we're talking about. And in the context of corruption, it's in the context of the inducement to reward or otherwise on account of a person doing an act in relation to their office or their employment. So you can see how they're setting out what the offence is. In relation to trading and influence, it's also similar in that regard, but what you're doing there is the gift or the consideration is inducing another person to exert an improper influence over the act of an official. This is borne out from things people would have read in the papers over many years in Ireland. The Act does extend to facilitation payments, as I call them in my own head, which is essentially the indirect provision of a gift where someone knows or reasonably know that it will be used to facilitate an offence. The Act goes further and it does extend to things like creating or using a false document. That would be a document that contains a statement which is false or misleading in a material particular, with the intention of inducing another person, again, in the conduct of their employment or their office or their position. And again, this is a person, this is not an official, to the prejudice of that person or another person. So you can see, certainly from a lawyer's perspective or from an internal compliance perspective, you might go, well, is something misleading? Well, is that actually go beyond misleading? Is that fraudulent? Or in fact, is that into the area of corruption? So it is actually quite broadly drafted in that sense. It does have further provisions that stray into the area of intimidation, which one would expect does not necessarily come up that often in a corporate environment. As you mentioned in the introduction, it can have extraterritorial effects. So the 2018 Act itself, of course, it applies to offences that occur in Ireland. It can also apply, subject to conditions, to offences that occur partly in Ireland. But it also could apply to offences that occur abroad. Now, there are conditions that attach to how that might occur and be prosecuted in Ireland, but the key issue there is that depending on a corporate structure, that means that perhaps if you have subsidiaries abroad and something occurs abroad in respect of that subsidiary, that may have consequences here in Ireland. Or more broadly, if you're looking at a corporate structure, if that subsidiary itself is subject to other anti-corruption laws, they themselves may have similar provisions. The particular issue for corporates, which is again the context today, is that the body corporate itself can be guilty of an offence, and that's committed where any of its directors or managers, the secretary and officer and so on, you know, are guilty of the offence. But it goes beyond that. It actually extends to any agent of the company or indeed a subsidiary of the company. So it's clearly called out that the extent of how corporate may be caught in this arena is very broad. And it's caught where, you know, there's an intention of obtaining or retaining business for the body corporate, or there's an advantage in the conduct of the business. There's also a separate offence which can arise where, you know, the offence is with the consent or connivance of a senior officer or was attributable to any willful neglect. For the purposes of context only, you know, what do the offences, what do the penalties look like? Well, you know, they're from fines of €5,000 to unlimited, 12 months imprisonment up to 10 years, forfeiture of any, you know, essentially gifts, and so on, and equally fines up to unlimited fines for the corporates themselves or any combination of that. But in the context, and maybe to set the backdrop, not only in terms of the offences, but also the defences. Well, firstly, corruption not occurring is the best offence, but in terms of the legal defences set out to the extent that they apply, it is a defence for the body corporate if it can prove it took all reasonable steps and exercised all due diligence to avoid the commission of the offence. And I think that just gives a flavour, Rob, for the context of the offences and perhaps the defence that's available. So I'll pass it back to you.
Great, thanks, Peter. That's a really useful background, and clearly there's some serious penalties there for getting this wrong. And I suppose that helpfully leads into our next panelist, who I can't see on the screen here, but we're joined today by Daniel McGinty. So Daniel, it'd be really good to hear from yourself in terms of your work with the Anti-Corruption Unit, and also your approach to enforcement. For example, whether your investigations are in response to whistleblowing and self-reporting, or whether you have any particular focus for proactive investigations, sectoral or otherwise.
Yeah, I hope you can hear me. We had a few technical issues this morning or this afternoon. Yeah, well, I suppose the big difference, and we're not around a long time, the Anti-Corruption Unit, we predate the new offences under the Criminal Justice Act, Corruption Offences Act 18. We're around since about March 2017. And it's always been a goal in a Garda Síochána to set up, particularly in the Garda National Economic Crime Bureau, which is where we are, to set up a dedicated resource that looks at bribery and corruption. And the big difference it makes is we are a proactive resource. So we proactively go looking for work. Of our cases, roughly about 50% is what we would class as foreign bribery. So that's where Irish companies, Irish corporates, Irish citizens, or people ordinarily resident in Ireland are involved in bribery abroad. Most of our stuff actually predates the 2018 Act. So as I'm sure you imagine, anyone who's involved in investigating any kind of economic crime, it's often years later that it comes to light. So a lot of the stuff, the body of work we're looking at is July 2018, with a couple of newer cases as well. But of those 50% of the foreign bribery cases, about half have come through our proactive work. So we scan media, we look at what other international police forces are doing, and we may look at particular industries or particular geographies where we think are high risk. And then we conduct our investigations. We also have a number of investigations that were started following whistleblower complaints, which are people within the company who kind of weren't happy with what was going on and reported it to us. So that's how they tend to come to light. As for where kind of geographies we're looking at, there's two kind of risk areas, I suppose. It's the industry and it's geography, really, from our experience. And industry-wise, the energy industry, which would be common worldwide if you ask anyone involved in anti-corruption, they'd say it's a very high level or high risk industry. And we have a lot of energy industry cases. Geography-wise, it's the developing world, so we have cases in Asia and Africa at the moment. We don't have any in South America yet, but speaking to my international colleagues, it's quite typical. of companies doing business in South America as well will experience such cases. And I suppose really it's anywhere a corporate interacts with a state body, particularly if we're talking about abroad and domestically, is a high risk industry. So we have a number of domestic cases really, and they're all in relation to procurement. So public procurement is where there's a massive risk. So if your company is involved in public procurement, just make sure that you're very careful about your prevention strategies. And you know, I always say this at these talks, it's great to have a prevention policy or strategy, but it really has to be living. So you have to be out there and training staff and keep very good records of the training. And we have 1 or 2 cases with Irish corporates where we were looking at the investigation and they were able to produce the training record for the staff. So I think that's very important from a corporate point of view. If the guards come knocking, if we come knocking, you can say, look, they did the training on this date and they signed such and such. So, you know, and even from the point of a Garda investigation, then we can show, look, this person knew what they were doing was wrong because they've done the training. They've done it, they shouldn't have done it. And from a corporate point of view, the corporate is careful to know what behavior is expected of their staff. And I think really buy-in from the top is very important. So it's important if you're a senior manager, even the CEO in a company, that you're seen to attend this training too. It's for everyone, and it's important to lead.
Yeah, thanks, Tanya. Yeah, that kind of aligns a lot with, I do a lot of work in privacy and that side of things, and very much post GDPR, it's a case of, you know, you need to have all of these policies, but you need to enforce them. It's not a case of preparing something and sticking it in the drawer and waving in someone's face. You know, if someone comes knocking on the door, it has to be actively enforced. And in terms of the actual policies and procedures, I mean, would you have any insights into, could you share anything in terms of kind of how much you'd study them or anything like that? Or is it a case of, I mean, like, look, you know, I mean, certainly myself, I can see where policies may have been prepared by an outside consultant and not tailored for the particular business. Do you come across that yourself?
Yeah, very often you can see a pro forma policy, let's say, okay, where it's very general. So it's important to tailor it to what you're doing. And in that regard, probably the more important thing in advance of your policy is some kind of risk assessment needs to be carried out to look, like I said, are you doing business in the developing world? Are you doing business in procurement, construction? Are you dealing with government officials in particular? You know, and this is where you look at it. Now, the bribery law and corruption law doesn't just cover interactions with public officials and governments. So just to be wary of that as well. We have a number of cases where in procurement, staff have been bribed by a supplier, which is also an offence. So it's not just government. So just to bear that in mind. And I think the risk assessment, if you have a proper risk assessment taken out, you'll see where your risks are and you can tailor your policy to that. And I think that is the vital thing, that you can see that it's a living document. I know our colleagues in the UK, where they have the Bribery Act 2010, so they've been operating a bit longer, and they have a similar offence of failure to prevent. And no cases that the SFO have taken for failure to prevent so far, unless one has happened recently that I am not aware of, have failed in court. And all the companies had policies, but they couldn't demonstrate that they actually implemented them and they actually delivered training to the right high-risk staff.
So that seems like one of the key pitfalls, really, is it? I mean, would there be any other kind of, you know, obvious clangers that I suppose you come across regularly and you'd be happy to share?
I suppose not particularly, but it's just a general awareness, and it isn't out there yet. And we have this act now. We're going into its 3rd year in July. It'll be enacted 3 years, and there still is a kind of lack of awareness out there, you know. And it's important, and it's great to see events like this that are spreading the awareness. But I suppose the reality of it is, people are only going to sit up and take notice of this when we have someone inside in court for it, and that's unfortunate. That's how these things work. But it's very, very important to pay attention to these things. And like you said, you don't want myself or one of my colleagues coming into your business and not have done these things, you know. And I think the risk assessment is vital. So we have come across companies that are involved in these sectors, and there isn't even lip service to it. Yeah. So it's just important to see that. And the other thing to bear in mind is a lot of these offences would come under Section 19 of the Criminal Justice Act 11. So there's certain reporting obligations as well. So companies should be self-reporting, and we have had a number of cases coming forward that were self-reported. And obviously, in our opinion, maybe the legal advice might be different. It's best to get the right foot out the door as quick as you can. So if something's gone wrong, come and bring it to us. Don't let us find out and come and knock on your door.
Yeah, no, it's a good point. And it's also a good point not to be looking at the 2008 Act in isolation. As you said, there are the self-reporting obligations as well. So there's obviously a wider context on that. And I might a bit later on bring Peter in on that, perhaps even as well, to speak to that. So that's great. Thanks for that, Daniel. And I suppose in terms of the risk assessments and the likes of that, what corporates should be doing, I mean, clearly this is something that's very much a corporate governance concern and should be high on a board's agenda. But equally, what you're saying there is that anyone within the organization would need to be aware, particularly if they're involved in the procurement side of things. And I think this might be something to lead in with Elaine, just in terms of the corporate governance side of things, but also being on a board agenda. Elaine, you've been obviously very much involved for LK Shields in working with organizations at the corporate governance side of things. What are you seeing yourself? I mean, we've heard from Daniel in relation to what he sees in the enforcement side of things and the uptake. What do you see yourself from the private companies' kind of current awareness on this?
Of course, thanks, Rob. Well, similar to what Dan and Peter are saying, it is quite important at the moment, and we're seeing it trickling onto board agendas all the time as an initial board agenda item and then as a recurring agenda item. And I think that's ultimately because it is the board's responsibility to make sure that these new regulations since 2018 are complied with, and the necessary policies and procedures, the overall framework is in place. I think Peter mentioned, and again, Dan, the stringent penalties for non-compliance and the developments in the Irish regime. It is an area that's becoming focused to the boards. If you look at the Criminal Justice Act 2018, it actually extends the veil of responsibility when it comes to a company. So this act apportions blame to the company as well as the individuals. So if you think of an officer of a company, an employee, an agent, or anyone who can be said to be acting for a company, well, they can be found guilty of corruption on behalf of the company. And it starts at the top, and that's why directors are becoming engaged in this. They're arranging training and they really are supporting this.
Okay, thanks, Elaine. Obviously, you provide company secretarial services, and obviously you work closely with a lot of in-house company secretaries. Presumably, this is a key role for themselves anyway. I mean, what would they, or what should they be doing within the business to assist the board?
Well, I'm sure all company secretaries are doing everything correctly, Rob. But
indeed,
I think the role of the company secretary has really changed dramatically in the last couple of years, even in the last 10 years, the role. I think in today's environment, the company secretary plays a more strategic enabling role, and that is making sure that directors are aware, making sure that they are protected, and then making sure these regular updates in terms of the legislation, in terms of compliance, are really embedded throughout the organization. I think for me, what I'm seeing as a company secretary over the last couple of years in relation to this is that company secretaries are kind of playing a key role in helping businesses manage the risk around this. And that's the risks associated with anti-bribery. And I think as a company secretary, some of the key things that we are doing or we should be doing are, well, we've talked about the risk agenda, we've talked about assessing the risks, and I know Kevin is going to talk about that as well, so I'm not going to get into too much detail on that. But some of the key things I think we should be doing is, well, understand the laws. As the company secretary, you really are the governance person for the organization, so understand the laws that apply to the business, especially if the business is a large organization or it's cross-jurisdictional, because there'll be different business interests and different laws to take into consideration. Ensure buy-in from the board and senior management. So this even involves getting this on the agenda item and making sure that the board understands, I suppose, the importance of this and it's getting the time that it needs. Subsidiary governance is so important, and I think it's a risk that is not appreciated. I think the approach here is to look at the risk in the jurisdiction, and is to look at the level of risk associated with that subsidiary and understand the laws in that jurisdiction. I think we're all great at looking at our topco or our head office in terms of making sure everything is in place, but we not forget that we put it on the back burner in relation to our subsidiaries. If there is current policies, where are they? These should be part of the risk assessment, so they need to be assessed. And then you're either enhancing those policies or you're designing new policies and procedures. And I think that's one of the key items, is once you design them, well, then what's next? Because you certainly don't want them sitting on a shelf gathering dust until someone like Dan comes to visit you. So the implementation is so important. So they need to be implemented fully throughout the organization, and it has to start at the top down, your directors, your senior management, and then all your employees. So they need to be implemented fully. There needs to be education and training around them, and that leads really then into, you communicate these anti-corruption policies, you communicate them internally. Well, what about your external people? Peter mentioned agents of the organization. So you need to educate your agents as well. They're all part of this anti-corruption circle for your organization. Okay, so then you've implemented them, you've told internally, you've told externally. Well, then what happens? Well, there's a process of continued monitoring, and you've got to review them on a regular basis to make sure, number one, they're working, and then to make sure, well, has a risk changed? Do we need to adapt them, or do we need to enhance these policies in terms of risk, in terms of a new merger, in terms of a subsidiary? And then I think it's really important that there has to be an internal mechanism for whistleblowing, to investigate whistleblowing. I'm sure all the company secretaries on the call at the moment are thinking, and where are we meant to get the time to do all this? This company secretary wears lots of different hats, and it can be board support, it can be internal training, it can even be the company secretary, and you're the company secretary and you're the GC. So who does this? And this is where people like myself and of course Kevin come into play, in that the company secretary of an organization will certainly be the sponsor for a project like this, but it's regular for somebody like us to come in and to assist with the independent risk assessment, to assist with the implementation, and to assist with the ongoing reviews. And I think that's something that Kevin has lots of experience in as well as myself, and I think he's got some good examples to give us in relation to that.
Yeah, great, and thanks for that, Elaine. Yeah, and from speaking with Kevin before, I know that like the whole kind of compliance culture is key, mainly to ensure that whatever corporate culture there is, that it flows from the top down. So on that point, Kevin, can you explain how a corporate culture impacts anti-corruption programs, and how an organization would go about creating that culture, corporate culture?
Yeah, absolutely. Hi, everybody. First of all, thank you to everybody on the panel and to everybody who's taken the time to join us today. Really great to get your time, and Rob, it's a great question. I think one of the things that you'll find often is this term corporate culture, but actually what is it? What are we talking about here? Because you'll understand in a moment, it's actually pivotal to making any compliance program, and especially anti-corruption compliance program, actually work the way it's intended. It refers to the beliefs and behaviors that determine how a company, its board, its employees, management, how they interact with one another and with other stakeholders and clients of the company. It's influenced by such things as national culture. So think about how we operate in Ireland. Think how you interact in other jurisdictions. Dan, you mentioned Asia Pacific and Africa. Different cultures, different way people conduct business in those different jurisdictions. Other things like economic trends, international trade, the size of your company, the size of your employee base, the products and the services. All of those have a way of influencing what we should be defining as the corporate culture. That corporate culture is led by everybody in the organization, but it needs to be set up, or the tone needs to be put in place by senior leaders. Senior leaders who are honest, they act with integrity and show respect for people, that they do business with, and with the law. These are just some of the values that can help create a good corporate culture. In contrast, leaders who choose to act and promote an ideology of profits at the expense of good corporate citizenship will be those leaders who will use phrases to defend corruption, such as, it's part of culture, it's where we operate, it's a cost of doing business, it's not a big deal, or our competitors are doing it, what's the problem? So that type of ideology can find its way into an organization and really turn a good corporate citizen into a bad one. That has a direct effect. I'm sure you can recognize the correlation, I guess, between a good corporate culture and a good way of implementing an anti-corruption compliance program. So very important right at the beginning, and we've touched on some of the aspects already that influence a corporate culture, and it's important to recognize that. There are ways to assess it. You might look at an organization and see really good published articles, but when you go and talk to people that actually work in the organization, you get a real feel for something's just not right. You take that to its logical end. If you've got a subsidiary or an investment somewhere else in the world, which may be a high risk jurisdiction, taking the next logical step and having a poor culture in those jurisdictions where you've got less locus of control can be really tricky and introduce opportunities for corruption and corrupt acts. So important to think about when you're setting up your compliance program, or if indeed you have one and you're on this call and you think, oh shucks, we haven't actually looked at it for a while. We haven't really looked at our policies, our procedures, and how we actually implement the compliance program. So yeah, Rob, very important to at least start thinking about that. And I think the next kind of we've touched on some of the aspects, and I think I want to go a little bit deeper and actually give some examples of what we're talking about when I'm going to put a couple of slides up, if that's okay. Hang on a sec, let me do that.
Yeah, so what you were saying there as well, I can only imagine, Kevin, that it's all well and good creating policies and procedures, and I know you're going to go into them, but I would imagine it's quite a difficult starting point to actually create a culture and to try and roll that out across jurisdiction. So yeah, I'd imagine a lot of heads need to be put together for that.
Absolutely, yeah. No, you're dead right. Yeah. So what I've got up on the screen is, unfortunately, a lot of compliance programs, that's it. Bribery, corruption, and fraud prevention policies. That is definitely not it, but there are a lot of companies who will spend time and money and effort developing policies that may be very precise and capture all the jurisdictional law that needs to be in it, but it doesn't start and end there. So what I've got up here is what I refer to as sort of a leading practice. Now, this model has been developed with reference to the OECD guidelines, to the UK Anti-Bribery Act, Dan mentioned it earlier, as well as the FCPA, which is the US Act dealing with foreign corrupt practices. And as you can see, we've talked about tone at the top. Now, that tone at the top, if you want to make it tangible, it finds its way into the policies and procedures. So good practices find their way into well-written, well-drafted policies. So working our way from left to right, I'll just quickly touch on these elements. Communication and training, it's already come up. Dan mentioned it, I think yourself, Rob, as well, mentioned it, and Elaine. We'll go into each of these in a little bit more detail. Internal control. So those three elements are what we call policies and procedures. Moving forward into the sort of proactive side. So this is getting ahead of the game instead of always being on the back foot. Let's get ourselves onto the front foot. Risk assessment, Dan, you mentioned this a little bit earlier. It is probably one of the critical or most important elements. I'll give you a few examples in a moment of how we helped clients pretty recently, and our starting point on both occasions was the risk assessment. So it's in the middle for a reason. Once you perform a risk assessment, it may have an effect both to the left and to the right. Monitoring, the next stage, is very important. Knowing whether your program is actually fit for purpose and working and doing what it should do. Let's go back to that. The whole point of the anti-corruption compliance program is to reduce the possibility of corruption in your business. So due diligence, a very important part. I'm going to explain a little bit later why it's essential to get it right, and there's ways to do it and there's ways that you should avoid doing. And then, of course, unfortunately, there are going to be occasions where you'll need to investigate. So there'll be a suspicion or an allegation that comes through various means. And one of the vehicles, I guess, for getting to know about that is a whistleblowing hotline or a tip-off line or reporting channel. So couple of these very important aspects. Code of conduct, that again sets the scene, sets the tone of the expected behavior that senior management would like the organization to adopt. So a well-written code of conduct will be will drive the behavior you want and try and minimize the behavior that you don't want. Touched on the whistleblowing system, we'll get back to that. There is a new whistleblowing directive here for the EU. Ireland, I think EU has until December to implement that, so we'll see where that goes. Risk assessment, compliance audit and analytics in the monitoring. We'll touch on some of that a little bit later, but very important. If you don't know if you're effective, you need to put in some controls to find out the results of your efforts. And then background research. Just dropping into some of the little bit more detail, communication and training. There's many ways to do it. A couple of examples, live and web-based training. In this day and age, we're not too sure when we're going to be able to get into a sort of classroom mode, but there are very effective programs available. In terms of who should we be training, all employees would be the absolute correct answer. But if you need to start redoing this right now, look at your accounting functions. So everybody that is able to move and record transactions, they need definite training there. Senior employees, now often the emphasis is not on the senior employees, but I think Dan hinted to it as well. The board and everybody at senior management needs to understand this is a dynamic environment, especially if you're involved in a business that is acquisitive, or a private equity firm, for example, taking stakes in various firms around the world and in different industries and different jurisdictions. So everybody needs to be updated on that. Specific targeted employees, what I mean by that, you may have employees that work in particular jurisdictions that deal with particular government officials. They could be more at risk or more exposed to the possibility of getting involved in corrupt activities. So they need particular training, and that can be also tailored training for that particular role as well. And then third parties, they should not be overlooked. Your suppliers, your agents, and anybody else who interacts on behalf of your company needs to understand your attitude and what you would like in terms of an anti-corruption compliance from them as well. A confidential reporting channel, very important. There's going to be new law, like I just mentioned. Very important to consider whether you need to have it internally, whether you can outsource it to somebody else to take care of. Being able to react is very important, and I think that just needs to be well understood. Looking at internal controls, strong internal controls should be focused around accurate record keeping, and that should go towards preventing concealment. Transaction monitoring of high-risk operations and processes. And again, your internal controls need to be designed fit for purpose. So those controls around transactions with government officials, very important to put in place. Your procure to pay, I know that's a very wide description, but there are controls that you can put within that cycle to help you identify and detect suspicious transactions. Of course, cash and petty cash, often a very easy way for sort of low value bribes to take place, especially in your sort of your operations or your subsidiaries that are, far away and in some of the high risk areas. Gifts and entertainment, unfortunately, from my experience, a lot of companies have hyper-focused themselves looking at that area at the expense of ignoring the real sort of high-risk parts of the business, which is unfortunate, but we are seeing a shift. And then cross-border shipping is a particular area that needs to be focused on, especially if you're in the business of transporting, importing and exporting either machinery, either goods. Dan, you mentioned the energy industry, and there's a lot of flow of materials and machinery through ports, and it's a hotbed of potential corruption. So just something to be aware of there. Now we come sort of to the sort of pivotal point, I guess, the middle, the most, what I consider as the most important element, which is your risk assessment. What's the point of a risk assessment? Well, essentially, understand your internal and external bribery and corruption risks that you've faced. So by doing that, you're able to also step back and have a look at what internal controls you currently may have to reduce the risk of actual corruption and bribery taking place. Considerations: the countries that you operate in, the sectors that you're operating or you're interacting with. We've mentioned, well, I've mentioned mining, oil and gas, telecom, as well as the aviation finance sector. Transactions such as political contributions and licenses. So these won't be obvious, but just sit back and think about, the licensing aspect, and that could be something that maybe you need to refocus on. The business opportunity itself, what is it? Is it of high value? Is it complex? Does it involve a lot of third parties? Another area perhaps to focus in. And then looking at business partnerships, joint ventures and third parties that are tied to public officials. Historically and still currently, unfortunately, there is a bit of a hotbed where your risks are really excessive. So how do you go about it? Well, document reviews, so looking at your policies, financial analysis, looking at these particular areas that I've outlined and having a deep dive into that. Transaction testing as well. There's certain ways that you can spot transactions that have been trying to sort of be concealed. You're looking for suspicions or red flags there. And then interviews as well, talking to people in your business. So talking to employees, talking to third parties such as your suppliers, gives you a lot of information which will go into the risk assessment. The outcome of your risk assessment is to focus where your efforts and where your investment needs to go. And it's obvious that your very high risk areas need some attention, a lot more attention than the low risk areas. Monitoring, equally important. So once you understand where your risks lie and you've implemented controls to reduce the risk, you've got to know how you're performing. So there's a number of ways to do it. Self-assessment is a very good way to begin. For example, if you've got a large supplier base, get questionnaires out to them, focus on your anti-corruption controls and see what answers you get back. That'll give you a lot of insight into how they view compliance to the law. That'll also help you identify any government customers and transactions that could be high risk. Asking your third parties, how do they do their own anti-corruption compliance is a very good way to understand whether you have excessive risks and monitoring whether yours are actually effective. Compliance audit, so internal audit might play a key role here. Transaction testing, interviews, again, very important to speak to people. People have information that is not always available in the records. And then your training compliance, I think we've touched on this, making sure that the training that you do is logged and available and of a certain detail that if suspicion comes up, you're able to use it in a constructive way. And then very importantly, data analytics. A lot of businesses, almost all businesses these days, will have a mountain of data. So you could look at rules-based testing, text mining, predictive modeling, and data visualization. So anybody that's familiar with the e-discovery side of the world will be familiar with some of these techs. So the tools are available. They're not expensive. They're becoming more accessible as well. it's a matter of you know, being willing to actually implement and make it important for your business. Just touching on sort of a second last bit, due diligence. I know it's come up. What is this due diligence? It's about understanding who your people are that you do business with or that you interact with. So background investigations, proportionate, obviously, to the risk. It's informed by your risk assessment, so you can see it's a very critical part. Those partners or people that you do trade with that come up high on the risk register, those will be the ones that you want to do a sort of a deep dive assessment. All your third parties, customers, partners present reputational compliance risks to your organization. So you need to spend the time, spend the money and the investment to actually understand who these organizations are. Getting behind the obvious is what we always recommend to our clients. And of course, you know, performing this independently and using reliable intelligence is a very key thing to consider there as well. And of course, should all of that sort of you know, be implemented and you still have a suspicion coming through or an allegation coming through, you need to be able to react through an investigation process. So having a well thought out and tested incident response plan, as well as your investigations protocol, very key. And again, we're not talking about being over technical or over investing. We're just saying, write a good fit for purpose procedure down, make sure you know how it works and that you have an objective way of investigating. And just on the investigation point, it's very key to have the right expertise performing the investigation. And in that way, you're going to reduce the possibility of getting things wrong, leaving good evidence not exposed and not considered. And yeah, so that's, I'm just going to go back to kind of the leading practice model. Rob, I think I've gone, hopefully I've done it justice. I've tried to unpack a little bit of what we consider to be leading practice. And you can see around the sort of perimeter of the model is, in other words, assess, monitor, communicate, and improve. And the reason it's circular is it is dynamic. This is something that needs to be lived and breathed, and it's ongoing. It's ongoing for a number of reasons. Business is dynamic. You have suppliers coming in and out of your organization. You have new customers approaching your organization to do business with you. There are a lot of risks all the time, and you know, it's got to make sense. Whatever you do needs to be proportionate and be risk-based.
Well, that makes sense, Kevin, and I suppose it goes back to what we were chatting with Daniel earlier on about, that you know, anything that's done really has to be looked at, that it shouldn't be static. It's not a case of putting something in a drawer.
Yeah,
it needs to be monitored and enforced. And what I'm taking from this as well is that this isn't something that we're just looking at from an Irish perspective, that there's other jurisdictions that may be in play, and this needs to be built into an overall model, so that we're looking beyond the borders of Ireland. So I suppose to kind of recap, and rather than me doing it, I think nearly it's a case of if we could even get some kind of top tips. And I'd like to bring Daniel back in if I can. And I suppose it's a question for everyone really, is if each of you were to share kind of a nugget of knowledge with anyone, that's whether it be a company secretary or upper management or whoever, in terms of what should they be looking at in terms of managing this compliance risk, and hopefully best positioning yourself to be able to rely on this defense of all reasonable steps and all reasonable due diligence. So Dan, if you wouldn't mind speaking to that, I'd appreciate it.
Yeah, and it's what I said earlier as well, I think, and it's vital, is that prevention policy is a living document. It's a living policy. It's not like we said, it's not something that's drawn up and thrown in a drawer. It's something that you can actively demonstrate that you've raised awareness in your organization about it, you've trained your staff, and you have very good records of that training. And I think that is vital, probably the most vital thing a company could do.
Great, thanks. Emer, if Elaine, sorry, if you wouldn't mind answering the same question?
Yeah, I think it's really important for the company secretary not to assume that somebody from risk or somebody from internal audit is looking at this or is going to raise it with the board. Just get it on the board agenda and start there.
Great, and Peter, actually more so than anything, rather than so much the nugget, there's something that was mentioned earlier on by Daniel, and if I could ask you this, obviously we all need to be more aware that this just isn't the 2018 Act. There's other relevant legislation in the context of anti-corruption and bribery. Can you just briefly speak to that and whether there's a wider context for Irish corporates that they need to consider?
Yeah, sure. No problem. There's a bit of that, and I think there's probably two separate answers. But yeah, no, quite correctly. Like, I mean, the context or the framing the discussion today was in, was broadly speaking the 2018 Act, but it itself has a much broader context. I suppose my nugget, just for the sake of the record, was the fact that how the offences are set out in the 2018 Act are much broader than people might think, and will and do pop up in places that people mightn't expect them to. I think in terms of the wider context, I think there's probably a private sector view and then sort of the interactions with officials / procurement view in relation to that. So from a private sector perspective, there's various other criminal justice acts that are relevant. They would touch on areas such as fraud, perhaps false accounting, and in particular mandatory reporting is what people need to be acutely aware of, such as policies and procedures and awareness of the law, but also what you do and what you need to do in that context. Beyond that, you're also looking at the Companies Act in relation to your requirements on that, under that, depending on what aspects might have arisen, be it in respect to companies' books or documents. In relation to officials, interactions with officials, the broader picture could be, ethics in public office. It touches potentially on the Lobbying Act. And I suppose within the context of everything is also protected disclosures. So within the context of this, you're never looking at one single act or one single potential offence or one probably single particular issue. It is a matrix of things that you're looking at, and within the overall context of the laws, it's actually potentially a moving target, because even in April, the Minister for Justice, released the implementation plan, which is looking at essentially the entire Irish position on economic crime and corruption, and looking at what needs to be done across government, and that itself has proposed amendments to the 2018 Act. So that all needs to be put into the mix when you're looking at it. I suppose stepping back from the law and what people need to be looking at, isn't it all part of, I think, two particular things. One, I think that what we're seeing in practice is the whole issue of corporate governance is getting much broader. It's becoming a very broad and more sophisticated board level issue where people are looking at much bigger issues than they ever did before. And secondly, there is obviously a marked shift in the regulatory environment and the potential enforcement in Ireland, and that's escaped no one. It's also seen in terms of the context and even the name of today's webinar, and Kevin in particular spoke to this about corporate culture. The culture that's driven by the board, and the culture isn't just through corporate governance through to governance, but it's also through to best practice, and we're certainly seeing that it's beyond regulatory at this point. And in fact, I'd welcome Elaine and Kevin's comments in relation to that point if there's time.
No, go ahead, Elaine. Sorry.
No, please go ahead, Kevin. That's fine.
Oh, thanks. No, Peter, absolutely right. There's one thing having a set of rules, and there's another thing actually appreciating why they were put there in the first place in a genuine way. So, that goes to the heart of it. Leaders who want to lead good organizations will they'll instill the values that will make sense when you're looking at implementing your response to legislation, you know, the legislation is written, as I understand it, in a very positive way. So I think taking a view of culture as a whole, a good place to start if you know, folk on the call haven't a clue where to, you know, to begin a journey or would like to start a refreshed journey, having a look at the culture, I think it'd be a great place to start.
Thanks, Kevin. On the Q&A, I think just looking at the timing, and I know we started a bit late, so if people are happy to bear with us. One of the first questions in from earlier on was, can you describe in more detail how the conduct of subsidiaries can give rise to criminal liability for an organization, corporation? If someone would be happy to speak to that.
I don't know, do they want the policeman's view or do they want the legal view?
I would like to hear the policeman's view.
Well, you see, Section 18 of the Criminal Justice Corruption Offences Act is really where it'll all come in. And that is where, and we've gone through it variously, and it really is, in reality, that is why we have these webinars. Corporates are interested because of the Section 18 liability offence. And under that act, agents, subsidiaries, can cause corporate liability or criminal liability for the corporate itself. And, you know, this is where the danger really will arise, where you have a subsidiary based, let's say, away, a satellite subsidiary out in Africa or in Asia, and they're doing great and they're getting great business in for the company. But what work have you done to see how they're getting that business? Why is there so many miscellaneous expenses being filed? What is the relationship with the government? You know, is there family relationships there? So these are kind of things. This is how you'll be exposed to or liable for prosecution, and it's very much something we will look at and we do look at. It's very important to carry out your due diligence, and I think this is where the due diligence comes in about who is running your subsidiary company, who's involved, and you know, I think that's where it comes in from a policing point of view and from a understanding of the law point of view. You can't just say they're a subsidiary company. You know, under the Companies Act, they're a separate entity, which is the old view where a company is a legal person. You know, it's not under Section 18. You have a responsibility for your subsidiary company, and that's how we look at it. And we do have a couple of cases, which have resulted because of this.
Absolutely, and to that point, Rob, and Dan, like, I mean, it's clearly set out that, like, I mean, the responsibility will flow up where the advantage flows up, essentially, and it should work that way. And I would just add that, like, I mean, in the context of how you monitor it, like, I mean, you should have some ability to do so in relation to subsidiary, but further in relation to agents. That's something that comes out today from Elaine and Kevin in terms of, well, how far does that go? Because if you're dealing with subsidiaries, that's one thing. There should be some corporate controls that you can put in place there. But then when you're looking at the scope of agents and agency and how far that goes, you really need to be careful, and that goes to the whole supply chain. And then in relation to just Robert, the second question about the scope of liability for private bribery, just to draw on one point that I was making at the outset, that, like, I mean, some of the offences relate to, you know, perhaps influence over an official, but some of them relate to just simply a person in the context of, say, their employment or their occupation. And to the extent that that's said to be an offence, well, then you just flip later in the act, there is a penalty for that offence. So it's just quite simply, has the offence, not quite simply on the enforcement side, I'd imagine, but from the offence perspective, it is, has that offence occurred, be it doesn't matter, it's a person, so it can be private sector, the penalty is set out. It's not that there's a regime that if it's an official, it is far worse. It's quite simply, there has the corruption occurred and there is a corresponding penalty set out for that corruption. It's not that there's two utterly different regimes depending on what happens, but though different, you know, associated or related acts may be triggered as well. Just in relation to the second question.
That's brilliant. Thanks both to Daniel and Peter on that. And I think we actually covered 3 questions there from the audience. So thank you for that. I think just looking at the time here, if we could just have a quick look at what the results here we are. So people can have a look at that. But while you're having a look at that anyway, what I would say is just to extend my thanks to our panelists for very interesting topic and very interesting and practical insights, particularly from the Garda perspective and also from the likes of Kevin and Elaine, who kind of roll up their sleeves and get involved and look under the hood in these things and help guide organizations. So thank you very much for that. And obviously not least, Peter, thank you as well for your legal review of that as well.
Thanks very much.
So certainly, anyway, there seems to be positive responses there. So I think Daniel might sleep easy tonight, which is helpful.
I was going to say, I did one of these probably about 12 to 18 months ago, and they had a similar question up, and there certainly wasn't that level of review and positive. So hopefully that bears out in reality, but that's good to see.
I think that might be to do with just their contacts of Kevin and Elaine. Maybe they're just well briefed.
They're just all the right people are here.
Exactly. Well, look, everyone, thank you so much, and we'll wrap up things. It's just shortly after 4. So I just want to say thank you all, and thank you for the audience for attending.
Great, thank you very much, everybody.
Thanks so much.
Thank you.
Take care. Bye bye.